Arbitration is a private and confidential process. Unlike litigation, there's confidentiality essentially baked into arbitration. The entire process itself is considered confidential. Arbitration is interesting because there's much more leniency with respect to the rules. There's no civil practice law and rules that you need to strictly adhere to. AAA has its own rules for complex matters of commercial litigation. JAMS has their own rules. But they afford the parties a lot of flexibility to essentially come to an agreement as to timelines for discovery, as to the scope of what's to be discoverable, as to whether or not there will even be depositions, as to whether or not there will be post-hearing judgment motions to be filed. So the parties can be a lot more creative in terms of the scope of how they're to produce evidence, what the extent of the evidence is going to be. And if there's a dispute between the attorneys or the parties about that scope, then the arbitrator can make a ruling. What is the benefit of arbitration? Well, arbitration in a way is a really sophisticated process. Similar to mediation, you do work through an alternative dispute resolution body, such as JAMS or the AAA. The AAA will, let's use them as an example, because we often are in front of them. They will provide you with a list of recommended attorneys. Both parties then need to review those recommended arbitrators, who again are either retired judges or attorneys that are sophisticated and can deal with complex matters in the field we're dealing with. And the parties will then rank the order of the arbitrators that they wish to select. Now, sometimes in arbitration, there could be one arbitrator that makes a decision. Other times it could be a panel of three. And to determine or know which one it's supposed to be, often you will look to your agreement or contract entered into. And that's where you're really going to want to see what was said in your contract. Is there supposed to be a panel of three? Is it supposed to be one, etc.? The AAA, if the parties can agree on an arbitrator, great. If they can't and they just put in their rankings, the AAA will ultimately select an arbitrator, and that arbitrator will be assigned to the case. The arbitrator will then reach out to the parties. There will be an initial case management conference where there's a brief conversation about the summary of the case, about the positions of the parties. I should also mention that in arbitration, a party files what's called a statement of claim. It's essentially akin to a complaint that you file in court, but ultimately it has a different name. And then the defendant, in arbitration called the respondent, then can put in an answer and any counters or any replies that they wish to. After the initial case management conference, there will be in place an order that lists all the scope of what's going to be exchanged and a timeline for when that will take place. And the arbitrator usually likes to have status conferences throughout the lifeblood of the arbitration. Here's where it gets really interesting. Unlike a case that's going to court, arbitration usually can have a hearing, which is similar akin to a trial. A hearing can take place anywhere from 6 months to a year down the road. That's a much faster timeline than litigation. So unlike the litigation process where you could be stuck for a couple of years, you actually could wind up with an award in arbitration within an 8 to 10 month period of time. So that's certainly something that's very valuable with arbitration. Arbitration award, which is the judgment, is essentially non-appealable. So if you don't like an outcome in arbitration, too bad, you don't get to appeal it. Now, there is an exception. The only way you could appeal a decision on an award in arbitration is if you allege what essentially arises to undue process. The arbitrator was arbitrary, the determination was arbitrary and capricious, the arbitrator was subject to some undue influence, there was fraud. It has to be something extremely egregious for you to be able to go into court, because that would be the process. There's an award. You'd have to go into court, allege that your arbitrator was arbitrary and capricious or committed some sort of fraud or was participating in an undue and unright manner. And then a judge will actually determine if that's the case. 9 times out of 10, that's not going to be the case. So arbitration awards are generally considered to be binding and non-appealable. The other consideration for arbitration is that it is a heck of a lot more expensive than court most of the time. And why is that? The court system, which is a public system, arbitration is private. That means you pay the arbitral body to initiate the arbitration. You're also paying the arbitrator's fees. So arbitrators, whether they're attorneys or retired judges, have hourly rates. And those hourly rates are taken into consideration. So if there's a panel of 1 arbitrator, then the fees are going to be lower. If there's a panel of 3, that means the parties are splitting the cost for 3 separate arbitrators. Benefits of arbitration, you can get a more expedited outcome, and you can know if it's a benefit that there's not an appeal that's available. The decision's the decision, so you can move along quickly and then you can domesticate the award in a state or federal court in order to collect on it if the opposing party is refusing to adhere. Detriments are, of course, it's going to be a lot more expensive, and the potential detriment is that you can't appeal. If you have any questions, if there's any follow-up, if you want to know more about these topics, feel free to email us or call us at 646-386-0990 and send us a note. Let us know what it is that you'd like to hear next time, because we as business attorneys are here to provide value. We're here to hopefully give everybody a general sense of the legal process and educate everybody a little bit about what the law looks like. Once again, I'm Ross Pitcoff of the Pitcoff Law Group, and I will see everybody next time.